It's just almost something you can expect to happen.
Is that right? So
yeah.
Okay, because I was wondering what happened, and I was like, "Whoa!" He says, "I better get in there." He says, "Okay."
Well,
And I remember talking.
I learned to dial back quickly.
Yeah. So just remember, if you're people who are listening, we don't know why we can only suspect why you're not allowed to talk and why the lines get cut off. Because I remember was speaking with Desert a few times. That happened many times when he also spoke. So anyway, you can continue.
Well, anyway, what I'm going to go back to is this Ed Woods. Ed Woods is a fool when he says that Bob Robidoux was a self-confessed murderer. This completely overlooks the fact that Bob was found not guilty. The agents died because of their aggression that day. This is what the jury verdict says. It's not conjecture, it's pure fact. The aggressors that day, again, proven by the verdict of a jury that was allowed to hear all relevant testimony, was the FBI. This can't be changed, it can't be ignored. Wood's statement admits that FBI knows Robert fired the kill shots. And the court verdict says he was in his right to do so. He was defending himself and women and children from an attack by an aggressor using deadly force, the FBI. Warriors defend their people. It is also a clear statement that Leonard is being held in prison as an act of vengeance against all Indian people. The only murder that took place that day was that of Joseph Stuntz, another fine young warrior who laid his life on the line that day in defense of his people and was murdered by the FBI. And we will see Joe Trembach and whoever actually pulled the trigger on Joe Stuntz put in prison. Nothing Ed Wood or Joe Stuntz or Joe Trembach can say can change the jury rendered fact that the FBI was aggressor that day. That the FBI murdered Joe Stuntz, wrongfully imprisoned Leonard Peltier, and led Bob Robidoux to be in a car that exploded in Kansas. And justice will come to those who have tried to cloud the issue for all these years to hide their own culpability that day in the deaths of 3 men and the vengeful false imprisonment of Leonard Peltier. The day's coming, justice is just down the road, and we're going to find it and bring it to all concerned in an appropriate way. What we need to understand is the FBI is hiding so many things. Now, I've been doing a lot of digging and research, and I have come upon communications between 2 FBI agents. One is this Ed Woods, who I just read his statement, and another is from former FBI agent M. Wesley Swearingen. Now, this is a statement direct from an ex-FBI agent. His name is M. Wesley Swearingen, and I quote, "I was an FBI agent in Los Angeles when Leonard Peltier was convicted. And I know from FBI documents that I read and from statements made by fellow FBI agents that Peltier was wrongly convicted of murdering 2 FBI agents just because he had agents investigating the case wanted someone to pay for killing 2 FBI agents. I know for a fact that the FBI is also covering up its culpability in the death of the 2 FBI agents." Now, that statement, coming from a former FBI agent, listen to it one more time. I know for a fact that the FBI is also covering up its culpability in the death of the 2 agents. Well, this ex-agent was in communications with Ed Woods, the man I read you the statement of earlier. Now, this is taken from a letter from Swearingen to Ed Woods, dated March 1st, 2005. This is a direct quote from Swearingen once more. "It's a terrible tragedy that Kohler and Williams were killed, but it is even more tragedy that the FBI has forfeited its motto of fidelity, bravery, and integrity by putting an innocent man such as Pratt and Peltier in jail for murders they did not commit." The Pratt he is referring to is Geronimo Pratt, who was jailed for over 20 years, and this Swearingen found FBI lies that set him free. This is a former agent that turned to be a good guy. Now, Woods had told Swearingen that he was trying to find a way to help Agent Collar's son, agent who died that day when he was the aggressor in attacking Indian people. And this was Swearingen's reply to that. This is an email dated 23rd of March 2005 at 12:30 p.m. If you want to help Collar's son, why don't you help the victim's family by having the Bureau face up to its culpability in a wrongful death suit and make the Bureau pay for the wrongful deaths? This one more time, as one agent telling another agent, the FBI is culpable. If you want to do something good about it, have the Bureau be sued for wrongful deaths by the FBI agent's children. In the same letter, Swearingen states, if Robidoux actually shot the agents, as he now claims, how could Peltier be guilty of pulling the trigger? If Peltier is guilty of conspiracy to commit murder, why are the conspirators not in jail with Peltier? Then he says, this may seem like a play on words or a matter of semantics, but if Peltier did not actually shoot Collar and Williams, wasn't he wrongfully convicted? This is one FBI agent telling another FBI agent. In a letter dated March 2005, Swearingen replies to Woods asking how he was able to state that he knew the FBI had framed an innocent man and was covering up its own culpability in the agent's death. This is Swearingen's reply. It's been 28 years since I retired from the FBI and 33 years since I worked with the racial squad in Los Angeles. There is no way that I can remember details specifying where and exactly what was said to support my belief of wrongful conviction. I was convinced that Peltier was convicted, that the FBI did its best to convict an innocent man. He goes on to say, now this is something we've been trying to make the FBI do, but he goes on to say, if you want to learn what actually happened in the Peltier case, this again is one agent talking to another. If you want to learn what actually happened in the Peltier case, I suggest you read all the FBI documents that have been released to date, and then read the thousands of documents that have not been released by the FBI. What is the FBI hiding? They have to withhold thousands of documents relating to the killing of Jack and Ron Williams, end quote. This is an agent stating that they're hiding something. Now, Leonard's lawyers have requested about 7,000 documents pertaining to this, and the FBI has refused to release them, and they quote, national security. Now, we're talking 1975. Pine Ridge Indian Reservation. 7,000 documents that the FBI won't release because of national security? Come on, give me a break. National security, they're covering themselves. They're covering themselves. They know there are documents that will be damning to what they did that day and damning to their total investigation into Leonard and the case. Now, I've got another FBI agent here I'm going to quote from. This one happens to be a former congressman also. And this was given on Friday, March 14th and December 2000 at the National Press Club by former Representative Don Edwards of California to the FBI statements against clemency for Leonard. And this is Mr. Honorable Don Edwards' statement. As a former congressman from California for over 30 years, a former FBI agent, and a citizen committed to justice, I wish to speak out strongly against the FBI's efforts in opposing the clemency appeal of Leonard Peltier. I served as chairman of the Subcommittee on Civil and Constitutional Rights in the U.S. House of Representatives. I took a personal interest in Mr. Peltier's case and became convinced that he never received a fair trial. Even the government now admits that the theory it represented against Mr. Peltier at trial was not true. After 24 years in prison, and remember this was written some time ago, in 2000, in 2000, Leonard Peltier has served an inordinate amount of time and deserves the right to consideration of his clemency request on the facts and merits. The FBI continues to deny its improper conduct on Pine Ridge during the 70s and in the trial of Leonard Peltier. The FBI used Mr. Peltier as a scapegoat, and they continue to do so today. He goes on to say, at every step of the way, FBI agents and leadership have opposed any admission of wrongdoing by the government, and they have sought to misrepresent and politicize the meaning of clemency for Leonard Peltier. The killing of FBI agents on Pine Ridge was reprehensible, but the government now admits that it cannot prove that Mr. Peltier killed the agents. Granting clemency to Mr. Peltier should not be viewed as expressing any disrespect for the current agents or leadership of the FBI, nor would it represent any condoning of the killings that took place on Pine Ridge. Instead, clemency of Mr. Peltier would recognize past wrongdoing and the undermining of the government's case since the trial. Finally, it would serve as a crucial step in the reconciliation and healing between the U.S. government and Native Americans on the Pine Ridge Reservation and throughout the country. Don Edwards, Democrat, California, retired. Member of Congress 1963 to 1995. Everybody who has looked at this case with an unbiased eye has found wrongdoing in the case. This even goes to the appeals courts that Leonard has taken his case to. On his Fargo trial, there was an appeal for an improperly imposed sentence. The appeal went before the Eighth Circuit Court was for the purpose of making Peltier's 2 life sentences concurrent rather than consecutive. At the time of the Peltier's sentencing, Rule 35B permitted every convicted defendant a second round before the sentencing judge. That means they can go and have a second round hearing. Well, in a decision filed on December 18, 2002, which affirmed the district court's decision, the appellate court stated that the sentence imposed were themselves legal, but they were imposed in violation of Peltier's due process rights because they were based on information that was false due to government misconduct. Under the relevant portion of Rule 35, it is true the court may correct the sentence imposed in a legal manner within the time provided for the reduction of sentence. Unfortunately, the time provided, the lawyers didn't get the motion filed in time for the time provided. But the key thing here is a court of appeals says that Leonard's sentences were legal but were imposed in violation of his due process rights because they were based on information that was false due to government misconduct. That's one appeals court. Another appeals court, which handled the appeal on the ballistics test, which the government hid from the grand jury investigating this case, which the government hid from the defense team, which is against the law. According to the law, the prosecution must share every bit of evidence that it has with the defense. So everybody is on equal ground. But on April 4th, 84, district court, the case for this ballistics was remanded to a district court for an evidentiary hearing. Specifically, the FBI teletype, which was what was hidden, of October 2nd, 1975, contrary to prior testimony by an FBI expert, stated that the Wichita AR-15, allegedly used by Peltier during the shootout, could not be linked to the critical 223 casing found near the bodies of the FBI agents. They hid this evidence. Their own crime lab said that the cartridge that they said fired the kill shots could not have come from Leonard's weapon that he carried. Expert witness Special Agent Evan Hodge of the FBI surprisingly divulged that he had testified before the grand jury on 24th and 25th, just prior to Peltier's indictment, and that he had not written the ballistics affidavit used to help extradite Peltier to the U.S. from Canada. The government had illegally withheld grand jury testimony from the defense team. They gave the Canadian officials false affidavits for Myrtle Poorbear, stating that she was Leonard's girlfriend and saw him shoot these people. Several months later, it was learned that after the extradition, it was learned that Myrtle Poorbear had been coerced and threatened by the FBI with losing her children, and she had never met Leonard Peltier in her life. She stated this in affidavits. Over 100 members of the Canadian Parliament, upon hearing this, demanded Peltier be returned. Of course, the U.S. government reacted the same way the U.S. government always reacts. It turned a deaf ear. Confronted by FBI teletypes, Hodge invalidated his earlier testimony, according to the government prosecutors, the most crucial testimony in Peltier's trial. While Hodge had testified that only he and an assistant had examined the evidence, notes and a third style of handwriting were present on the lab report. Denying on the stand a third participant in the evaluation of the evidence, therefore committing perjury, Hodge later claimed he had misspoken. That's one of the things we find here in dealing with Leonard in this case, as we have FBI agent after FBI agent after FBI agent perjure themselves on the stand in a federal trial, in a federal courthouse, in front of a federal judge. These federal officers raise their hands and swear to tell the truth, and they tell lies. And the amazing thing about it is, when the lies are exposed, nothing is done. They are not charged with any kind of crime for perjuring themselves. If one of us were to get up and perjure ourselves, we go to jail. You know it. You see people go to jail for perjury all the time. But the FBI perjured themselves in this case over and over again, and in doing so have sent an innocent man to prison. Now, perjury that may cost somebody a $5 bill is one thing, but perjury that costs somebody 33 years of their life, that's something else. But the FBI gets by with it. And that's one of the things we have coming up, hopefully, in the future. We're going to be challenging the FBI to a debate at the United Nations. A time frame will be set at a later time, but that's coming. We'll see if they'll stand up and talk with us. We'll see if they can stand there with their own lies and see their own records put in their faces where they did lie. Now, Gerald Haney was on the 8th Circuit Court of Appeals. They declined to set aside Peltier's conviction, but the court noted the record as a whole leaves no doubt that the jury accepted the government's theory that Peltier had personally killed the two agents after they were seriously wounded by shooting them point blank with an AR-15. This is the AR-15 that Leonard was supposedly shooting with. It did not fire the shells that they used as evidence. The FBI own evidence people said it didn't come from his gun. Didn't come from his gun. But they convinced the jury, because they did not allow the evidence into the court, that it did come from his gun. Judge Haney expressed the view that the FBI was equally responsible for the deaths of the agents. In a 1991 letter to U.S. Senator Inouye in support of grant of clemency for Peltier, this is an appeals court judge who had to look at this. He said the United States government overreacted at Wounded Knee. Instead of carefully considered the legitimate grievances of Native Americans, the responsibility was essentially a military one, which accumulated in deadly firefight June 26, 75. The United States government must share responsibility with Native Americans for the firefight. The government's role cannot be ignored. This is when the firefight took place at Wounded Knee, the second Wounded Knee. You know, the day that all this happened, June 26, 75, 3 men died. Court verdicts clearly state that two of the men who died were aggressors. They were aggressors. A third man got killed that day. The FBI teletypes say 2 agents got killed and gave their names and ages, and said also an Indian man got killed. Well, the man who got killed that day was Joe Stuntz. On June 26, 75, an act of murder was committed on Jumping Bull Ranch. That day, federal agents were the aggressors in a deadly attack on the residents of Jumping Bull Ranch, where Leonard, Joe Stuntz, and many other people were. This is a fact. It's not conjecture. The fact is borne out by the verdict of not guilty by reason of self-defense and handed down to 2 people who were tried for the deaths of the 2 agents that day. A jury that was allowed to hear all the evidence available understood the law. And the law states, one who is not the aggressor in an encounter is justified in using his adversary when he reasonably believes he is in immediate danger or that his family or anyone else is reasonable to use deadly force against a deadly attack. The jury in their verdict found the FBI aggressors that day using deadly force. 2 of the aggressors died. 1 innocent man was found guilty for the happenings that day because the jury was denied access to all evidence. And a third man, Joseph Stuntz, was murdered that day by the aggressors, the FBI. The FBI put out the story that Joe Stuntz was killed by a long-range sniper shot. But, now listen to this. South Dakota Assistant Attorney General William Delaney, again, the South Dakota Assistant Attorney General William Delaney, who was on the scene, noted that Stuntz's body to him seemed to have been struck by a burst across the back, implying automatic weapons fire at close range. NPR reporter Kevin McKierman, who the FBI unintentionally let on the scene that day, corroborated Delaney's observation of torso wounds, saying, quote, blood was leaking from the jacket sleeve, and added that the corpse was wearing an FBI field jacket. McKierman also stated repeatedly he saw no bleeding indicating a head wound. This is corroborated by side view and full-face photos of Stuntz after death and the possession of former WKLDOC attorney Bruce Ellison that revealed no head wound. But the body was given to FBI coroner W.O. Brown, who rubber-stamped it, head wound. Now, this W.O. Brown is the same coroner that the FBI used to rubber-stamp all their vicious acts up there. This is the same coroner that ruled Anime Aquash died of exposure, even though she had a bullet wound in the back of her head. He ruled she died of exposure because that's what the FBI told him to state. Joe Stuntz was a defender of his people, was murdered by court-proven aggressors that day, the FBI. He was not afforded a trial. He was summarily executed by a burst across the back by the all-powerful, all-lying FBI. The agent in charge of this murder was none other than Joe Trimbach. He and whoever pulled the trigger to summarily execute Joe Stuntz needs to be called before the courts and made to answer for his crime. You ever wonder why Trimbach yells so loudly about Leonard? He thinks that enough noise about Leonard will keep the spotlight off of his own culpability in the deaths of the 2 agents that day, and most of all, the cold-blooded execution of Joe Stuntz. Trimbach belongs in prison. Leonard belongs home. Joe Stuntz deserved justice. Once again, a jury decided that the aggressors that day were the FBI when they were allowed to see all the evidence. What we're doing right now is reframing the argument that has been presented for Leonard all these years. For too long, people have tried to defend Leonard. Leonard's not the one who needs defending. He's the one who needs freeing. We intend to attack the FBI lies, the inconsistencies, their perversion and obstruction of justice, and we intend to show that what the FBI is keeping Leonard in jail for and why they're hiding 7,000 pages of documents is because they murdered a man that day, and then they tried to put off 3 deaths on a bunch of Indians. Well, the thing is, my friends, those Indians were on their own property, on private property. The FBI gives a story that the 2 FBI agents, 2 of the nation's finest, saddled up their iron ponies and chased a man onto that property for a pair of stolen cowboy boots. Now, do you think the U.S. government, the FBI, really sends FBI after a pair of stolen cowboy boots? Nah. You send the BIA police, but not 2 agents armed with shotguns, automatic weapons, and handguns after a pair of FBI boots? Nah. You know, as Joe Trimbach has put out vicious statement after vicious statement about Leonard. Joe Trimbach is another FBI, ex-FBI agent. He was the special agent in charge of the Minneapolis office that time. He was in charge of what happened at Jumping Bull Ranch that day. Joe Trimbach is a liar. He's just a pure liar. He has lied in court during the Wounded Knee trial of Dennis Banks and Russell Means. This champion of the people, Joe Trimbach, this preserver, this enforcer of federal statute and law, he denied that he applied to a court for wiretaps on the Wounded Knee telephone. Now, he was asking for wiretaps on the Wounded Knee Defense Council telephone. He was trying to wiretap a defense team. But he denied it. He denied it in spite of the presence of his signature on the application. Trimbach lies a lot. I think that's what he kind of gets on at, is he lies. You know, surprise witness at the same trial was former AIM member Louis Movescamps. Prosecutor Hurd himself reviewed affidavits produced by the FBI. After meeting Movescamps, he apparently had some doubts as to the witness' honesty, so much so that he requested that a lie detector test be administered. Now, this special agent in charge, Joe Trimbach, defender of the public and upholder of laws, he refused to give his own witness a lie detector test. I wonder why, Joe. Also during that trial, Trimbach testified that the FBI had no informers infiltrating the defense team. This lie was exposed when Douglas Durham's infiltration of AIM became known. This is our FBI, my friends. We're changing their name now from FBI to FIB. They fib. They don't know the truth. They make up their truth, and they feed it to the public, and because the public is just kind of sitting there like sheeple, the public eats it up. But it's the FIB now. A couple months later, during the trial of Leonard Crowdog, Trimbach testified that he had no idea that Durham had been an informer. This is this Douglas Durham. Although one of the 3 agents in his own Minneapolis office who followed him to the stand, who went to the stand right after Trimbach, acknowledged that Durham had contacted him at a special phone number at least 30 times during the Banks Means trial. This agent said that Durham had been known to Trimbach from the start and that he had notified Hurd and the other U.S. attorneys about Durham. Trimbach stated he didn't know there was an infiltrator into the AIM defense team. Another agent came up right behind him and said Trimbach knew about him all the time and actually notified Hurd and other U.S. attorneys about Durham. Trimbach again, this detractor of Leonard Peltier, this man in charge of the shootout that day, lies again on the stand as a public servant, a federal employee, in front of a federal judge in a federal trial, in a federal court, stands there with his federal stinking badge and raises his hand and lies. And what's amazing, my friends, he gets by with it. He gets by with it. At the Cedar Rapids trial of Dino Butler and Bob Robidoux, Trimbach denied knowing that Banks or the AIM group were on the Jumping Bull land. That was a lie. Trimbach is a liar. He is hiding his culpability. What happened that day is something that Trimbach was in charge of. He sent 2 young agents on a mission to get a pair of stolen cowboy boots, knowing that AIM was on that property, and they were on that property because 57 people had died violent deaths in 3 years in that community, and they had died violent deaths resulting from abuse by the goons, who were a FBI-funded hit squad that was trying to take a quarter of the reservation away and give to mining interest. There seems to be some uranium there. But what Trimbach did that day is he sent these 2 young men in to be slaughtered, knowing that the people were going to defend themselves, but also knowing his plan was, as soon as it happens, get all the people we can in there and wipe AIM out, and we can get the land back finally. Trimbach's plan didn't work. But he did, within an hour and a half, have 250 armed people there. But the next morning, the FBI relieved him of his command because the FBI realized he had made one terrible mess. And the FBI realized that they could be held culpable for what happened that day in the deaths of their own agents and in the murder of Joe Stuntz. That's what the 7,000 pages of documents that the FBI is hiding is about. They're hiding their culpability in the murder of Joseph Stuntz and in the deaths of their own agents, who Joe Trimbach set up to go in and be sheep led to slaughter so Joe Trimbach could be a hero and wipe out AIM. He didn't wipe out AIM. He had 2 of his own agents killed. He was duplicitous in the murder of Joe Stuntz. And he's had Leonard Peltier imprisoned for 33 years for a crime he did not commit. One of the things parole board has asked Leonard to do over and over again is sign a statement of remorse and contrition for the death of the agents. Even after 33 years, Leonard can't sign that. He knows he can't sign that. He didn't murder those agents. Why would he sign it saying that I'm sorry I did it when he knows he didn't do it? Why would he ever do that? We want people to come help us make the FBI face up to what they've done. We want Leonard Peltier set free underneath the 30-year law for parole. After that's accomplished, we want restitution for Leonard Peltier for 33 years of his life that's been taken away. We want his life made whole, or as whole as can be made, for the destruction of 33 years of it, for the loss of his family for 33 years, for not being able to bounce his grandchildren on his knee, for not being able to hug his family, We want Leonard free. We want restitution for Leonard. And then we want justice for the people who actually committed the crimes that day. The Federal Bureau of Investigation of the United States committed the crimes that day. Not Leonard Peltier, not Dino Butler, not Bob Robidoux, especially not Joe Stuntz, who was murdered by the FBI that day. We want justice. We're going to demand it. We're going to step up every day and keep demanding it. We ask you again to help us in every way you can. Call that White House phone number I gave you earlier. That's 202-456-1111. Ask them to ask the president, and these notes go directly to the president's desk. Ask the president to ask the Attorney General, Eric Holder, just simply to do one thing. There's been so many laws broken in this case. Justice has been so subverted in this case. We just want one law upheld, and that's the 30-year law concerning parole. Ask the president to instruct the Attorney General to ensure that Leonard Peltier is freed underneath the 30-year law as it is written. We don't want anything special. We don't want a new law. We don't want an overlooking of a law. We want the government for one time, in this case, to enforce the law. That's all we're asking for. Daniel, I thank you for your time this evening.
Yeah, no problem. It's actually been great to listen to you. It's great having somebody else speaking about it, talking about it, and bringing out some of the points that even if you read it over the internet and you read both sides of the story, the way you put it, it puts it into a greater perspective, a great understanding.
Well, Daniel, what we try to do is point out the things that can be easily missed by all the information that is out there. The things that people may just gloss over. You can read, there's hundreds and thousands of pages written about this, but there are very valid things that we're just pointing out here. And there's two sides to every story. The whole story is a very sad story.
Yes.
But right now we're in a time race actually to save a man's life, and that's what we're trying to do is save Leonard's life. We need him out of prison.
All right, Wanbli.
We'll talk to you next Tuesday, 6 o'clock.
All right.
Thank you, my friend Dan.
You're welcome. Anytime.
Doja.
Oh. And that was Wanbli, one of great activists for the Free Leonard program, and also rescind Wounded Knee medals. Great story behind all that. If you look up at the time and what the cavalry did at that time, and why the medals should be rescinded, and we'll probably get into that sometime later on another show with him to really get in depth on that situation. Right now, I have Reality Check with Ross Montoya.